Welcome everyone to our webinar on the impact of AB 5 and how that relates to the mortgage industry. As many of you know, this legislation was passed this year in California, and it relates to employees and independent contractors. And the California Mortgage Bankers Association had received numerous questions from the industry about how specifically this piece of legislation would relate to those working in the mortgage industry. So I asked two of our members, Michael Pfeifer and John Jaffe, to present information that hopefully will provide some clarifying information for you on the impact of AB 5. So our speakers today are Michael Pfeifer, who's General Counsel for the California MBA. He's been active with us for several years. He is an AV-rated attorney with over 40 years experience and is currently of counsel at the law firm of Kirby and McGuinn in San Diego. Also joining us today is John Jaffe. John is a partner at Mayer Brown in San Francisco and a member of the Consumer Financial Services Group. John has also been very active with our association for many years. So thank you, gentlemen, for joining us today. We'll go ahead and get started. Michael, I think I'm turning it over to you.
Yes, thank you, Susan. I'd like to begin with just a brief summary of what's been going on with AB 5. AB 5 was a bill that was obviously introduced in 2019, I believe, but it was signed into law on September 18th by Governor Newsom. And it comes about as a result of a case that was decided in 2018 called Dynamex Operations West v. Superior Court. And in that case, basically, the California Supreme Court sort of refined or updated the standard for determining who can be classified as an independent contractor. And that prompted some legislative activity, and so basically AB 5 is the result of that, and essentially it adopts the decision in the Dynamex case, but goes even a little bit further, because Dynamex was limited in terms of its scope to basically independent contractor situations involving the wage orders issued by the Industrial Welfare Commission. This expands the reach of that decision. And so basically on January 1st, the test that was enunciated in Dynamex will be used to determine independent contractor under the California Labor Code, and also some additional, the Unemployment Insurance Code and some other provisions, and that will be the governing standard, and not just on the wage orders. It will reach out into other areas of legislation. We're going to try to explain in this presentation how that happens, how Dynamex has been expanded, go over some of the exemptions, talk briefly about the enforcement, and also we're going to explain some of the impact of this on our industry. So next slide, please. The title of this slide suggests, I'm going to give you a little bit of background, so the context is going to be important, because the reason why this is important is not just background, because the statute actually harks back to these decisions and the rulings on these decisions and actually mentions them by name. So before AB 5, there were these two major Supreme Court decisions. And whether someone is an independent contractor or an employee has not just been for the parties to decide in a contract. There's always been a body of law governing that status. And but prior to AB 5, it was all determined by the form or the type of claim that the worker wants to assert. If it was unpaid wages, breaks, unemployment, whatever, the different kinds of claim were governed by this different standards. For 30 years, essentially the Borrello case, decided in 1989, was the governing case, and that involved a situation where you had agricultural laborers who were engaged to harvest cucumbers. The employer was claiming that they were independent contractors, and Borrello said, no, we got a test for determining that, And basically, there's 11 factors that were applied to determine who was going to be and who was not going to be an employee and an independent contractor for purposes of the benefits and rights and duties associated with that relationship. Next slide. In Dynamex, which decided in last year, the Supreme Court revisited Borrello and made a sort of a modern, odd speaking about 2018 versus 1989 as modern, but that's basically what things have moved so fast in this area. Basically, Dynamex has maybe not so much reinterpreted, but refined the holding in Borrello and extended it. And there, the court concluded that in the circumstances of that particular case, which involved truck drivers and the California Industrial Relations Transportation wage orders, that Borrello was not the proper test, and the so-called ABC test was the correct test. That's a test that's been used in other jurisdictions. So in that sense, California sort of conforms with practice in some of the other states, and basically requires the employer to prove that the worker, A, is free from the company's control, B, performs work outside the company's primary business, and C, is regularly engaged in the trade that the worker is hired for, independent of the work for the company. That's a simplified version of it. We're going to discuss it in more detail as we go through. But prior to Dynamex, factors B and C were not part of the independent contractor analysis, and those are difficult standards to meet. So I'm going to make a request. I can hear someone typing in the background. If you're not, if you could put it on mute, that'd be great because I can hear the typing. The changes made by AB5 extend the protections of Dynamex to workers and apply the ABC test to all California wage orders, to the Labor Code and the Unemployment Insurance Code. Does not extend the test to tort claims, but claims under the Government Code, and doesn't get into harassment or discrimination issues. Those are different tests. So it grants enforcement authority also to the Attorney General and to certain city attorneys, and extends this private Attorney General penalties that can be imposed to the areas of the law, the Labor Code, the Unemployment Insurance Code, covered by AB5. So it expands the enforcement, it expands the coverage, and basically makes it much riskier for employers in their classification of independent contractors. So let's get into the specifics of it, if you would. Next slide, please. These are the standards. There's a presumption that a person is an employee unless the hiring entity demonstrates, you can see here, A, the worker is free from the hiring entity's control and direction with respect to the performance of the work. B, the worker performs what is outside the usual course of the hiring entity's business. And C, the worker is customarily engaged in independently established trade, occupation, or business of the same nature. I've underlined the key operative words there, and there's going to be litigation over what those words mean. Next slide. The key part of AB5 are the exemptions, and I've listed here a number of the exemptions. Mainly, they're organized by occupation. A lot of them are just set forth specifically. It kind of tells you the strength of the lobbying resources. So you get licensed insurance agents, certain healthcare professionals. Others are not exempted. Securities dealers, direct sales persons, real estate licensees, and that's going to be significant for the impact on the mortgage industry. Commercial fishermen, workers providing licensed other, barber, cosmetology services, and that sort of thing. The reason this has been so much notoriety is because some of the occupations not specifically exempted are the so-called gig economy workers, like Uber and Lyft drivers, campaign workers, and other things. And I couldn't resist putting in the specific areas of exotic dancers and rabbis and other clergy. Those are just like in the analysis, people put those things together. Next slide. The exemption for the real estate licensee is an important one, and I've set that forth here. This is the actual part of the language of the statute, and as you can see, it specifically talks about the way it defines the exemption is by basically saying people who are licensed under these specific code sections, and then if they don't fit within those code sections specifically, then the determination is governed by Borello for all other purposes. So the specific language of the statutory exemption for real estate licensees is critically important. Next slide. One of the key exemptions is the so-called professional services exemptions. It's defined here basically as individuals who perform work under a contract for professional services are also exempt. And being exempt doesn't mean that you're just free to do whatever you want. It simply means that the rules in Borello govern. But the hiring entity has to demonstrate the following 4 criteria. Basically, showing that the service provider maintains a separate business location, is able to set or negotiate his or her own rates for the services, and set his or her own schedule, is customarily engaged in the same type of work as the work performed under the contract, and regularly exercises discretion and independent judgment. If you listen to those, you'll see they're very similar to the ABC test. So it's sort of an exemption, but it's kind of not an exemption. The exemption for professional services has got a lot of limitations and conditions on it, and they define what is a professional service. And so I guess that's another criteria, another limitation, which is, marketing, administration, human services. In other words, they specifically list them. Next slide. There's another exemption for business to business, and again, if you satisfy these conditions, Borello governs rather than the ABC test. And there's a number of criteria listed. I've listed them here. Service providers free from the contracting entity's control and direction with respect to the performance of the work. That's basically taken right out of the ABC test. Provide services directly to the contracting business, not to the contracting entity's customers. That's a significant element, and it's going to disqualify a lot of businesses from serving as independent contractors. The service provider's contracts in writing, that's no big deal. Service provider has any required business licenses, that requires a separate licenses. That can be significant for the mortgage industry. John may talk about that. Another key element of this is that the service provider maintains a business location separate from that of the contracting business. The definition of what separate means under those circumstances is going to become significant. Service providers engaged in independently established business. So again, you're seeing the flavor of a lot of the ABC elements in this exemption. So it's not going to be easy to satisfy this exemption. Next slide. And then these are the rest of the factors. So the service provider actually contracts with other businesses to provide the same or similar services and maintains a separate clientele. Service provider advertises and holds itself out to the public as available to provide the same or similar services. Service provider provides its own tools, vehicles, equipment. Service provider can negotiate its own rates, and consistent with the nature of the work, the provider can set its own hours, location of work, and not providing the type of work for which a license from the state contractor's license board is required. So basically, they're not allowing basically building contractors and that sort of thing to fall within this exemption. So the exemption does not apply to an individual worker as opposed to a business entity who performs labor or services for a contracting business. So you have to be, if you're just an individual worker as opposed to a sole proprietorship, operating as a sole proprietorship with tax reporting and everything else like that, you don't get to use this exemption. Next slide. Retroactivity, it's a little murky how this all applies. AB 5 applies to work performed on or after January 20th, or January 1st, 2020, but it specifically says that specified labor code provisions of the bill apply retroactively to existing claims and actions to the maximum extent permitted by law. Well, what that is not entirely clear. There's some disputes about what the maximum extent permitted by law is. But the ABC test applies retroactively with regard to wage orders of the Industrial Welfare Commission, which makes sense because that's what Dynamex held. But then it also says, and labor code violations relating to wage orders. What relating means to in those circumstances is unclear. And if the exemption would relieve an employer from liability. So there's some murkiness about the retroactivity, and that could very possibly be the subject of further litigation. So next slide. Now we're on to John's material now, so I'm going to happily relinquish the line to John and let him go forward with his part of the presentation.
Thanks, Michael. Well, as Michael indicated at the beginning, many people have expressed concerns about the potential impact of AB 5 on the mortgage banking industry. As I'll explain in the 5 minutes left in this webinar, I think many of those concerns are misplaced. For purposes of this discussion, I considered the most obvious areas that are specific to our industry. That would be mortgage loan originators, processors and underwriters, and third-party vendors. So let's start with the most obvious one, mortgage loan originators. We've got 3 different licensing regimes in California that MLOs can operate under. One is the Residential Mortgage Lending Act. I think that's the one used by most mortgage bankers in California. The other is the California Financing Law. And then the third, of course, is the Real Estate Law, which is subject to the jurisdiction of the Department of Real Estate. The first 2 are subject to the jurisdiction of the Department of Business Oversight. I'll start with the California Financing Law. Actually, I'll just start with the DBO. Historically, the DBO has said, in order for somebody to be an individual loan originator, to be exempt from our licensing regime, they have to be an employee of a licensee. In other words, if John Jaffe is a loan originator for Michael Pfeifer Mortgage, John Jaffe does not have to get a California Financing Law license so long as I am operating as an employee under Michael Pfeifer Mortgage. And not only has the department taken that position informally, I think that there's predicate for that in the statute. If you look, for example, at California Finance Law, Section 22010, it says that finance lender means blah, 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 except that an employee, when acting within the scope of his or her employment, shall be exempt from any other law, blah, blah, blah. So basically it means if you are an employee of a licensee, you don't have to worry about getting a separate California Financing Law license. Next slide, please. The same is true under the Residential Mortgage Lending Act. An employee is not required to be licensed when acting within the scope of his or her employment. So bottom line is, your MLOs, if you're RMLA licensed or CFL licensed, they've always had to be employees. You weren't supposed to be treating them as independent contractors, and I don't think many people were. That takes us to the real estate law. And some people are concerned that real estate broker licensees are going to have a competitive disadvantage because they'll be able to treat their MLOs as independent contractors. I don't know that that's truly the case. While it's true that the Department of Real Estate says that real estate agents may be treated as independent contractors of their employing broker, that's only part of the story. Next slide, please. AB5 exempts, also I should note, AB5 exempts real estate licensees from provisions of AB5, at least the ABC test. But as Michael noted, what does that mean? Does that mean that somebody who's licensed by the Department of Real Estate is exempt, or does that mean that they're exempt if they're engaging in traditional real estate brokerage activities, like representing the buyer or seller of property? I think clearly that's the case. The less clear case is, does that mean if somebody is licensed as a real estate licensee, but they're using that license to engage in mortgage activities, does that exemption from the ABC test control? It's unclear, it's uncertain, there are arguments on both sides. Next step, please. Furthermore, AB5 doesn't declare that real estate licensees are statutory employees. It merely says that Borrello will apply as opposed to Dynamex, and that a broker's statutory duties under the real estate law shouldn't be considered factors in the determination of which test should apply. And that's because the real estate law says real estate licensees, agents, salespersons have to be subject to a certain level of control by their employing broker, and that should not be held against them in determination of whether the ABC test or the Dynamex test should apply. Bottom line is, it's not clear whether mortgage loan originators operating under a real estate broker license are exempt, but even if they are exempt from the ABC test, they're still going to be subject ultimately to the multi-factor test. Okay, let's skip on down to, because we're running out of time, how AB5 might impact treatment of underwriters and loan processors. Susan. So, same discussion. At the end of the day, if your loan processors and underwriters are employees, you're not going to worry. The only worry is if you've been treating them as independent contractors, and I would argue that you shouldn't have been. Again, if you look at the CFL, it says that a loan processor or underwriter means an individual who performs duties as an employee at the direction of and subject to the supervision and instruction of an MLO. Goes on to say an independent contractor may not engage in the activities of a loan processor or underwriter unless that person maintains a mortgage loan originator license under this division. You read all that together, and at least there is an argument that your processors and underwriters under the CFL should be employees and not independent contractors. Next slide. The same is true under the Residential Mortgage Lending Act. Very similar language. I won't read through it because of lack of time, but very similar language. And also under the real estate law. So if you, next slide, please. So the question is, what happens if you contract with third-party processors and underwriters? Then you would be subject to the business-to-business analysis. Is that contract underwriter, contract processor, somebody who fits within the business-to-business exemption? And we're running out of time, but basically there's strong arguments that many of them will be, but there are also arguments you have to look at it on a case-by-case basis. Are they free from the control and direction of the lender? Probably. Are they providing services directly to the lender rather than to its customers? That depends on the type of service we're talking about. For contract underwriters and processors, yes, they're providing it to the lender, not to the consumer. Is there an agreement in writing? Yes. Is the work performed something that requires a license? Well, that's the tricky part. If there is a license required, does that mean it's up to you as a lender to ensure that they have the license in order to fit them within this particular niche of the exemption from the ABC test? It's a question that's the answer is unknown at this time. I won't go through all the elements, but a lot of people were concerned with the treatment of third-party vendors, and my point is that in those instances, look at the business-to-business exemption and see if it will apply. And I think in most instances, many instances it will. There are going to be some vendors out there who are going to have problems. Field service companies, I think, because those vendors treat most of their reps as independent contractors, and maybe they're going to have to be treated as employees unless they can play with the edges here. And we're out of time, and
John, this is Susan.
We started Susan. Yeah.
We started a few minutes late, so this is important, so I don't want to cut you off. I think that I know that you can't see the screen. I got a little bit off on your slide, so I'm on the RMLA slide right now.
Oh, well, I bypassed all
might
of it,
impact. I thought you did. I was like, so I just want to let people see this. So now I'm on the DRE slides, and we still have time.
We apologize, everybody. Yeah. And there were technical difficulties. I've not been able to get into the presentation, so I'm having to work off my own deck here.
So the last
rather
slide
than me
that
going
you had
on,
was
I
just
think
the impact of AB5 for the mortgage industry. And so, I think that if you and Michael are open to take some questions now.
Yeah, sure.
If you thank you guys for that presentation. And again, we did have some technical difficulties. We ran a little bit late starting, so we're running a little bit over, but happy to field any of the questions that you might have. You can type those into the questions dialog box on the right-hand side of your screen here. So as a question...
And while you're doing that, I will note that, I'll simply note that this is going to have to be filled in by I think, probably regulation, interpretation, litigation. So there are still a lot of issues, a lot of questions that are unanswered and will probably remain, if not unanswered, at least uncertain for a while.
And this might be that might be in this area. So the first question is: we know when this will be cleared up for MLOs. Do we now treat them as independent under DRE?
I think the answer to that is you should consult with your own legal counsel. I think that the circumstances are going to vary. My personal take is that it's going to be difficult, I think, to get an MLO who's a DRE licensee qualified as an independent contractor under AB5. And by the way, I should note that the IRS attacked that treatment a number of years ago. There is in the the Internal Revenue Code, an express exemption from W-2 treatment for real estate brokers and real estate agents. But the IRS in California attacked the practice as it was applied to mortgage lenders licensed as real estate agents. And the argument was the exemption was something that was negotiated by the National Association of Realtors and California Association of Realtors, very, very strong lobbies. And it was limited to real estate licensees who are acting as such, that is, representing the interests of buyers and sellers in real property. It was not intended to cover mortgage lenders, mortgage brokers. Many of those resulted in settlements. So we don't know today whether that's going to be the same case for AB5.
So the next 5 questions all relate to essentially the same thing, which is how will appraisers and appraisal management companies be treated under AB5?
Well, good question, and the answer is again unknown. I don't want to venture into that particular briar patch publicly, candidly.
If so, the business to bit, just a question from somebody who's not an attorney, John. The business to business exemption doesn't take care of the AMCs.
I think that's the one that's going to be applied, right, John? I think that'll be the one that'll be the focus, the focal point of the discussion. But
yeah,
taking care of it and giving them the exemption. If you look at those rules, the professional services exemptions, if you look at them carefully, they're not easy to jump through all those hoops.
And the same is true with business to business. Both of those exemptions have a lot of hoops to jump through.
Yeah.
So next question, how will commercial mortgage banking firms be treated? Should originators be employees or independent contractors?
It is, I think, a facts and circumstances. They're not going to fit in the ABC test. I mean, if you look at it, they clearly are subject to control, I think. Maybe not. It depends on the way in which they operate, the particular commercial mortgage banker operates. But generally speaking, they're subject to sufficient control that they're going to be employees under the ABC test, which means then you have to look to see if one of the exemptions applies and whether or not Dynamex Borrello is going to apply to you.
Yeah, and I would add,
Michael?
I would add that the B of the ABC test is particularly difficult for commercial mortgage bankers because it says the work performs work that is outside the usual course of the hiring entity's business. That means they're basically out, working for other people. And
yeah, I would say that if you look at the ABC test, everybody is going to be an employee under that test.
Yes.
Everybody in our industry.
Yeah.
It's just hard to find somebody within your organization who's performing work that's outside of the usual course of your business.
So and
who's not subject to your control and direction.
Yeah, exactly. So if they're, if their activity has to be measured under the ABC test, then they need to be an employee. So the action, as it were, for commercial mortgage bankers or anybody else basically is in the exemptions. And if you're talking about real estate licensees, they have to fit probably within the DRE, license exemption.
Yeah.
John just reviewed it.
Yeah.
Problems.
Yeah. I agree. I think just about everybody's going to be an employee under the ABC test, with some limited exceptions. So then you have to really look at the exemptions and to see if they can fall outside of the ABC test.
Okay, those are all of the questions that I see right now. Any other questions? If we probably have another moment or so if you'd like to type a question into the question dialog box. While I'm waiting to see if there's any other questions that come in, just a reminder, we will have a recording of this webinar available on our website, probably in the next day or so. And for more information on this and other California legislation, we've got two opportunities coming up. One is the California MBA Legal Issues and Regulatory Compliance Conference. That's happening December 2nd and 3rd in Newport Beach. And then we have just set our 2020 Legislative Day, and that will be Monday, March 23rd, right here in Sacramento. Gives you an opportunity to hear our legislation we're following in 2020, and also be a part of groups that go over and meet with key members of the California State Legislature to talk about issues that are a priority to the mortgage banking industry. So 2 great events for you to check out, available on our events page on our website. I think those are all the questions that we have. So gentlemen, thank you again for being presenters today. Thank all of you for joining us. And again, we'll make this webinar available on our website. Everybody have a great day. Thank you.
Thanks.